Hello, everybody. Happy Sunday. And as I said, this is the second of three videos for a tribute in Memorial Day weekend. We finished up the Constitution yesterday, and today we're going to talk about the Bill of Rights. The 10 most important parts of the Constitution. And you'll understand why when I go into greater detail. Now, the Bill of Rights are commonly known, is what the name that's commonly given to the first 10 amendments to the Constitution. And they were proposed following what was at times pretty bitter, the ratification debates in 1787 and 1788. And they were written to address objections and concerns raised by the Anti-Federalists. And what it does is it adds to the Constitution specific guarantees of personal freedoms, rights, clear limitations on the government's power in judicial and other proceedings, and explicit declarations about powers not granted or mentioned. And this was due in large part to the efforts of James Madison. There he is again. And at this point he was a representative from Virginia. And what he did was study closely the deficiencies of the Constitution that were pointed out by the Anti-Federalists. And he sat down and he wrote a series of corrective proposals. Congress approved 12 articles originally of amendment on the 25th of September 1789 and submitted them to the states for ratification. And originally Madison wanted these inserted into the Constitution at the appropriate areas, but instead they were just added as supplemental additions. And as we know, the Articles 3 through 10 were the ones that got approved. The first article was, it wasn't defeated. It's still pending towards the states, but I doubt it'll get approved because it's just a revamping of the representation in Congress, and that's not going to get approved. The second one was later approved as the 27th Amendment, and we'll get to that later. The First Amendment, and I'm sure we all know what this discusses, but here's the text of it. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or of the right of the people to peaceably assemble and to petition the government for a redress of grievances. Congress is expressly prohibited from establishing a national religion and cannot in any way prevent the people of this country from practicing the religion of their choice in a peaceable fashion. Congress also cannot in any way limit the freedom of speech or of the press. Congress also cannot prevent the people from assembling peaceably and petitioning the government to hear their concerns and whatnot. Initially, the First Amendment applied only to Congress, but it has grown to include all federal and state government bodies. Now, here's the kicker. Second Amendment. The text. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. I don't know how much more clear you can get. So I want the gun grabbers to listen closely to what I've got to say. This amendment protects the rights of the individual to keep and bear arms, and no law can be made which infringes on that right in any way. To those of you who love to cite the first sentence, I'll help you out a little bit. A militia is defined as a citizen army. The citizens have the right to keep and bear arms for defense of life, home, property, and rights. Since the citizens are the first line of defense in our country, the people have the right to be just as well equipped as the United States military. This is to prevent tyranny from taking hold in the United States. And any law that has been passed that restricts or limits the right to own a weapon is therefore unconstitutional and null and void. Yes, that includes the rights of everyone. Now, I understand what you're saying about felons and people who are mentally ill. Did we not speak earlier about rights that can be removed through due process of law? And, or in other words, if you're convicted of a crime, they can do that. That's your only instance right there. Through due process of law, if you've been convicted of a crime, you cannot own a weapon. There you go. That's it. You, just as much as me, have the right to be just as well equipped as the United States military. So to all the gun grabbers, there you go. You'll take mine from my cold dead hand, but you better be careful because the bitch is going to be hot. Now we're going to Amendment 3. No soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. This amendment is, it comes from during the Revolutionary War, where the British Parliament passed the Quartering Acts and was allowing soldiers to be quartered in private homes, and it restricts that. And it says, Congress has the power to determine how this will happen, but in time of peace, soldiers cannot be quartered in anyone's private home without the consent of the owner. The Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Okay. This amendment guards against unreasonable searches and seizures. Basically, quite a few sections of the Patriot Act should be invalidated because of this, yet we still are allowing cameras everywhere and TSA agents to grope us and other such atrocities. Why? Why are we allowing this? Because we've been dumbed down. We don't know what's in the Constitution. And because we don't know, they're able to take shit away from us. That's why I'm doing this. Alright. We go to the Fifth Amendment now. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment or of a grand jury, except in cases arising in the land and naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. This amendment protects against double jeopardy and self-incrimination and guarantees the rights to due process, grand jury screening of criminal indictments, and compensation for the seizure of private property, that under the eminent domain, which I think the government has freaking abused over the course of the last few decades. Government owns way too much land, but we spoke about that in the last video. And this amendment serves as the basis for what we know as Miranda versus Arizona from 1966, your Miranda rights. So You have the right to an attorney. You have the right to remain silent, yada, yada, yada. So this amendment served as the basis for that. The Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. This amendment simply guarantees the rights to defendants in a criminal trial. And, you have the right to an attorney. You have the right to have witnesses in your favor. You have the right to know what you're being charged with. You have the right to a jury of peers. It's just basically the stuff that we see in court cases, high-profile court cases. It's all of that stuff right there in the Sixth Amendment. And in 1963, in the Gideon versus Wainwright decision, SCOTUS ruled that this applied to both federal and state courts. All right. The Seventh Amendment. In suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. This amendment simply guarantees the right to jury trial in civil cases that deal with claims of over $20. It prohibits judges from overruling findings of fact by juries in civil trials. And the Eighth Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. It's pretty self-explanatory, but it leaves the term excessive wide open for interpretation. The most frequently litigated clause is the cruel and unusual punishment clause. It was only occasionally applied by the Supreme Court before the 1970s, generally in cases dealing with means of execution. The Supreme Court has found that some poor prison conditions constitute cruel and unusual punishment, as in Estelle versus Gamble in 1976 and in Brown versus Plata in 2011. Personally, I think prison should be crappy. You've committed a violent crime against the country, against the people of the country. Why should you be living in a hotel? Just my opinion. I could be wrong, but I doubt it. Alright, the Ninth Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. This amendment declares that there are additional fundamental rights that exist outside the Constitution. These rights enumerated in the Constitution are not an explicit and exhaustive list of individual rights. It was rarely mentioned in Supreme Court decisions following World War II until it was cited by several justices in Griswold versus Connecticut in 1965. In that case, the Supreme Court voided a statute prohibiting the use of contraceptives as an infringement of the right of marital privacy. So that's where you have that. Now my favorite amendment, and the one we should all listen closely to, the 10th Amendment. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. And as I said, this is one of the most important amendments to the Constitution. It reinforces the principles of the separation of powers and federalism by providing that powers that aren't granted to the federal government nor denied to the states are reserved to the states or the people. And it doesn't give any new powers or rights to the states, but what it does, it preserves their authority in all matters that are not specifically granted to the federal government. And this is the third part of the Constitution that is violated by Obamacare. If you followed my videos, then you know that nowhere in the Constitution is the federal government granted power over a private citizen's health care. Therefore, according to this amendment, health care is an issue that should be dealt with in each individual state. Each individual state should have its health care handled by the state government and not the federal government. Shed a little light on the subject there. Also, the Department of Education in the executive branch. Does anyone recall the Constitution mentioning education? I certainly don't. I know the Constitution verbatim. I could sit here and recite it to you all day long. I do not recall anything in the Constitution mentioning education. Therefore, the Department of Education is unconstitutional. Yes, it is. Congress frequently circumvents the 10th Amendment by invoking the Commerce Clause in Article 1, or by threatening to withhold federal funds for a program from uncooperative states, such as South Dakota versus Dole in 1987. Now, granted, the federal government is the supreme law of the land, but they have certain powers that have been granted in this Constitution. The states have certain limitations put on them. The federal government has certain limitations put on them. This amendment gives all issues that do not fall in those three categories power to the states. The states are sovereign. They're sovereign states within a sovereign nation. They have certain degrees of sovereignty. And when you step on states' rights, you're violating the 10th Amendment. Just like during the War for Southern Independence. And I don't call it the Civil War because it was not a civil war. A civil war is two groups battling over control of the same government. The South wanted its independence because it felt like the federal government was being too encroaching on their rights, which it was true. So there we have our Bill of Rights. I'm going to go ahead and talk about Amendments 11 and 12. And then in tomorrow's video, we will do the Reconstruction Amendments 13, 14, and 15. The 11th Amendment was passed by Congress on March 4th, 1794, and ratified by the states on February the 7th, 1795. And here we have the text of it. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. And basically this amendment restricts the ability of individuals to bring suit against the states in federal court. 11A was adopted to overrule the Supreme Court decision in Chisholm versus Georgia in 1793. So that right there just shows you that a constitutional amendment can tell the Supreme Court to go play in traffic. In that case, the SCOTUS held that states did not enjoy sovereign immunity from suits made by citizens of other states in a federal court. Therefore, 11A establishes that federal courts do not have the authority to hear these cases brought by private citizens against the states. Nonetheless, the Supreme Court has held that Congress can abrogate state sovereign immunity when using its authority under the Bankruptcy Clause or Section 5 of the 14th Amendment, which we'll discuss later. The Supreme Court has also held that federal courts can enjoin state officials from violating federal law. I think I might have screwed up in my notes there. But here we go with the 12th Amendment. And this was the modification of the Electoral College. We talked earlier when discussing the Electoral College about the issues that came about, and we'll get into that. It modifies the procedure for electing the president and the vice president and replaces the procedure that was discussed in the previous video from Article 2, Section 1, Clause 3. The amendment was passed by Congress December 9, 1803, and was ratified by the states on June 15, 1804, and the new rules took effect for the coming 1804 presidential election and have governed all subsequent elections since then. And the text, the electors shall meet in their respective states and vote by ballot for president and vice president, one of whom at least shall not be an inhabitant of the same state with themselves. They shall name in their ballots the person voted for as president, and in distinct ballots the person voted for as vice president. And they shall make distinct lists of all persons voted for as president and all persons voted for as vice president, and of the number of votes for each, which lists they shall sign and certify and transmit sealed to the seat of government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes for president shall be the president, if such number be a majority of the whole number of electors appointed, and if no person have such majority, then from the persons having the highest numbers not exceeding 3 on the list of those voted for as president, the House of Representatives shall choose immediately by ballot the president. But in choosing the president, the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. And if the House of Representatives shall not choose a president whenever the right of choice shall devolve upon them, before the 4th day of March next following, then the vice president shall act as president, as in the case of the death or other constitutional disability of the president. The person having the greatest number of votes as vice president shall be the vice president, if such number be a majority of the whole number of electors appointed. And if no such person have a majority, then from the 2 highest numbers on the list, the Senate shall choose the vice president. A quorum for this purpose shall consist of 2/3 of the whole number of senators, and a majority of the whole number shall be necessary to a choice. But no person constitutionally ineligible to the office of president shall be eligible to that of the vice president of the United States. There we go. That's a mouthful, but it does change things. While it didn't change the composition of the Electoral College or the duties of the electors, it did alter the process for electing the president and the vice president, and it stipulates that each elector must cast distinct votes for president and vice president instead of just 2 votes for president. And additionally, the electors cannot vote for presidential and vice presidential candidates who both of them reside in that same state of the elector. At least one of them must be from a different state. For instance, I recall in 2016 people were saying they'd like to see Newt Gingrich and Herman Cain as a president and vice presidential team. That can't work because Cain and Gingrich are both from Georgia. And the Georgia electors would have to abstain from voting for one or the other if they had happened to win. If no candidate receives a majority of the total votes, the House of Representatives chooses from the top 3 for president, and the Senate will choose from the top 2 for vice president. And to prevent a deadlock from leaving the country without a leader, the 12th Amendment provided that if the president wasn't chosen by March the 4th, which at that time was the beginning of the presidential term, then the person who was elected as vice president would then be acting president until the president is chosen. But it does not state that in the amendment. It doesn't state for how long the vice president acts as president, or if the House could still choose the president after March the 4th. but one would assume that the vice president would act as president until the president is chosen. And beginning with the election of 1804, each presidential election has been conducted under the auspices of the 12th Amendment. And only once since then has the House had to choose the president in a contingent election, and it was necessary because no candidate won an absolute majority of 131 votes in 1824. And we can go into that in a different video later on, or you can look up the election of 1824 yourself and do a little reading. So there's amendments 1 through 12, and we're going to cut this video off here. This might be the shortest one I've done other than the preamble, but I'm going to save the Reconstruction Amendments 13, 14, and 15 for tomorrow's video, and we will pick it up and continue on with discussing the amendments to the Constitution until we've completely reached the end. Hope you guys enjoyed yourself. Have a wonderful and safe weekend. Peace.